Hello, and welcome to our webinar, Tenant Troubles, Common Issues and How to Manage Them. Let's give it a minute for more people to log on. Hello again, and welcome to our webinar, Tenant Troubles, Common Issues and How to Manage Them. My name is Maria, and I am with Zillow Group Rentals. First, I'll start with a few housekeeping tips. First off, you are in listen-only mode. If you have any technical issues at any point during the presentation, please contact the Technical Support Center at 866-678-2846. And just let them know that you're watching Tenant Troubles, Common Issues, and How to Manage Them. I also want you to know that the webinar is recorded and will be sent to all registrants after the webinar. If you get disconnected for any reason, you'll get a copy of the webinar recording. Also, thanks to everyone who sent us questions ahead of time. We have over 1,000 attendees dialed in today, so we won't be able to answer everyone's question, and we do prepare questions ahead of time based on questions that were emailed in. We'll do our best to follow up with all questions afterwards, but please understand the sheer number of attendees makes it a little difficult for us to get to all of them. If you're just joining, welcome to our webcast. This presentation is being recorded, and we will get started. All right, so what exactly is Zillow Group? Zillow Group encompasses 3 primary consumer rental brands. You're familiar with these ones. They're Zillow, Trulia, and HotPads. As a landlord, when you use Zillow Rental Manager, you create one listing and it's posted on all 3 sites. So, Zillow Group Rentals, why would you use it? Well, we're twice the size of any other rental network out there. We have over 7 million qualified renters searching our sites, and renters searching on Zillow Group are more likely to have a credit score in the 600 to 700 range. Plus, most of these renters are ready to move in within the month, and we provide all information that helps you save time by knowing which contacts are more qualified. In addition, we have our rental resource center. For landlords who are brand new and older, property managers of all types, our resource center includes information for everyone. In addition, we have dozens of customizable tools and forms, and it's going to make any type of renting a breeze. Also, if you haven't heard, you can now add a rental video walkthrough to your listing. Download the Zillow Rental Manager app on Android or iPhone and select Create a Listing, and then boom, take a video. Adding a video allows prospective tenants to envision themselves in your place before contacting you. This saves you so much time, so only interested renters are going to contact you. The Zillow Rental Manager app allows you to do this and so much more. If you haven't used Zillow Rental Manager before, give it a try. You'll be surprised at what you can find. Once again, this webinar is being recorded, and just a quick reminder that while we hope you find this information useful, this content should not be construed as legal advice, and it's intended solely for informational purpose. If you need any legal advice, we definitely recommend seeking professional counsel. Now, I'll introduce our first presenter, Steve Weinman. He's the designated broker of Family Real Estate Service, Inc. He's a licensed real estate broker since 1984. He's been a landlord for over 39 years. He's an administrator and instructor for the Mount Rainier Real Estate School, and he's an instructor for the Rental Housing Association. We are so lucky to have Steve with us here today, and now I'm going to give it to him, and he'll take it away.
Thank you for that introduction. Today we're going to be talking about some basics as it goes to relating to your tenants in a professional manner. So as we get started today, if you have additional questions, please enter them. We will try to get to them all later. But it's important that when we are renting that we start off on the right foot with our tenants. Establishing a positive yet professional relationship is key. When you get ready to turn over your rental property to a prospective tenant, we need to make sure that they feel welcome, they feel comfortable, and they've been provided the information they need to have a good tenancy and have a good relationship with their landlord. But it is a professional, not a friendly type relationship. Typically, either at lease signing or on move-in day, you'll want to spend some time welcoming them and reinforcing what your expectations might be. Some owners prefer to provide a written information sheet to their tenants, maybe include important phone numbers for police, fire, where the local schools are, how to reach the landlord in case of an emergency, and advising that they should call 911 first and then notify you if there's any emergency activity on their property. As a landlord, you also need to be reachable. Many times, tenants will put their notice in writing and or repair requests in writing, and they're required, typically by law, to send those notices and requests to the address where they pay rent. So if you happen to use a P.O. box or something like that, you should make sure you check your P.O. box on a regular basis and not just check it when you're expecting money in the mail. Providing an emergency phone number is also very helpful to get information quickly when there's a problem at your rental. A lot of the newer voice over IP phone systems allow your voicemail to be delivered to you by email or text message, so you're notified immediately even when you're away from your residence. As you're showing someone around the property, you should show them, certain important things that you want to know that they take care of, where the shutoffs are for electricity, gas, water. Let them know you're going to be doing regular semi-annual or other inspections during the course of their tenancy, and making sure they know what you expect as far as maintaining your property, whether it's cutting the grass, maintaining yard, that it goes from the curb to the middle of the alley, whichever is relevant to your property. Make sure tenants understand when the rent is due, how they're supposed to pay it, what forms of payment are allowed to be paid. Do you take checks, money orders, cash? Do you go pick up the rent? If you happen to use any of the online payment resources that are available, or you would give your tenant some access to direct deposit their rent into your bank account, you need to have a way to shut off or restrict those payment types in order to protect yourself in a legal situation. Typically, accepting of rent will oftentimes cancel any notices that you have already served on your tenant. So you don't want them to be able to pay $20 into your account and stop a notice that said they were required to pay maybe the full rent of $1,000. You should clarify your quiet hours and reiterate whatever policies you have on activities and what's allowed as far as guests and visitors in your property. When it comes to documentation, you should have a policy and follow it for each and every tenant. Everyone should be treated the same and have the same type of documents on file. Screening reports, rental application forms, all leases, all notices sent to and from your tenant, and things like that are important to be kept. Typically, we suggest that owners maintain their records at least 7 years after a tenancy is terminated and the file is closed. Even with applications that you have rejected, you should maintain a record of those and the paperwork for several years and follow the statute of limitations in your state as far as keeping those records. While you are in possession of those records, they need to be kept in a locked and secured format, because many of these papers, screening reports, and applications have Social Security numbers or copies of Social Security cards, copies of identification, and you want to make sure that you are protected against potential identity theft of your clients. Also recommend that you keep a backup and archive your data on a regular basis. In my office, we typically scan and save to PDF files for basically forever storage in encrypted formats, and be able to take a DVD of all the data and take it off-site So in case there was ever a fire or some damage in my office, that I won't lose all of my records. When it comes to each tenant's file, whether it's a hard copy or digital, you want to keep a signed copy of all signed agreements. We want to keep all communications. We want to keep maintenance and repair records. What did the tenant request? What did you notice maybe during an inspection? Document all of these records. Keep a folder for each property, keeping the bills and records related to the property. This will also help you track the useful life of your property. Things like carpet, countertops, painting, roofing, furnaces, all have a life. Some are going to be needed, that information will be needed to be able to charge tenants that move out based on lost remaining life. Should they damage something that may have a 5 or 7 year life, and 2 years into the place they've damaged your carpet and you need to charge them for the remainder, you need to know how long that is. Also, it comes for budgeting. For budgeting purposes, knowing how old your furnace is, how old your roof is, so you can plan for major repairs and updates will be very helpful. Also, keeping copies of all receipts, any issued to the tenant for their payment. In most states, if a tenant pays in cash, a written receipt is required to be given, but we recommend that all receipts be written with a duplicate copy kept so that you have a record. And in addition, to maintain a tenant ledger for each tenant separately so that you have an accurate record of any charges for rent, late fees, utilities, etc., along with the payments received and a running balance. This simple ledger could be done on a ledger card in a written form, on an Excel spreadsheet, or there's made software programs that will take care of these things for you. This gives you the information to know who owes you what, when it's due, and allows you to present that as evidence if you end up in any kind of legal situation in court. When it comes to making repairs on your property, first we want to encourage tenants to let us know when there's a problem. A lot of tenants believe that if they withhold repair requests, maybe the rent won't go up. Well, as a matter of doing business, we want to raise our rents on a regular basis so they know that they're not related to each other. But we want to make sure our properties are being taken care of and maintained. Recommendation, best practice, to do regular inspections of your property, checking for any needed repairs, any preventative maintenance that may be necessary, and to ensure your tenant's compliance with your contract. Many states have laws that specify time constraints to begin repairs when they're requested. In Washington State, for example, 24-hour for some repairs, depriving tenant of heat or water, 48 hours if they don't have hot water or other things, and 10 days in all other cases. Depends on the nature of the problem. So you need to be prepared to respond to repair requests however you become aware of them. But you also must have the tenant's cooperation or post the proper notices to enter before performing these kinds of repairs. You should establish a policy that says what happens if the tenant locks themselves out of the house or their apartment. Do you charge them a fee? Do they have to use a locksmith? What is your policy? Have a policy and stick to it. Found that using quick set smart key locks will allow you to rekey locks quickly without having to hire a locksmith or exchange lock sets. Any of my staff can go to a property in less than 30 seconds, can establish a new lock and new keys. So if a tenant reports lost keys or something like that, it's easy to resolve without having to go through a major expense. However, it's inevitable at some point that the use of the property might be disrupted. Maybe there's a major plumbing leak or electrical work that needs to be taken care of that might impact the tenant's access to the property. You should coordinate these things with your tenant and plan for logistics both with your vendors and with the tenants to lessen the impact on tenants. Typically, landlords are not responsible for providing alternate housing for tenants. However, whatever seems reasonable in the case is what's recommended. By maintaining that maintenance log and record, you'll be able to have planned for these things more in advance. The more you communicate with your tenant and explain what's going on, the better your relationship with your tenant will be. So take some time to coordinate these things, notify them of what's happening, make sure you issue any correct notices for access, let them know if there's any certain restrictions that might be necessary after the work is finished. Maybe they can't use a shower for 24 to 48 hours, but they can still access the property. Another very important recommendation is to maintain your list of vendors. Keep it with you at all times, whether it's in your smartphone or on a 3x5 card. But when a problem arises, it's often simpler and less expensive to deal with people you've already have a relationship with for billing and for getting prompt service. During emergencies that are widespread, oftentimes you'll get faster response from your regular vendors, but always have backups in mind. Also, when you're planning ahead for major repairs, doing them when it's not an emergency, when the water's not pouring through the ceiling, you'll have time to get competing bids and be able to do work that's off-season, and that can save a considerable amount of money on the landlord's part. When it comes to responding to problems, disputes from tenant to tenant, disputes between maybe manager and tenant, you should have a set policy in place and avoid at all times the appearance of discrimination. There's a policy available through most human rights offices that talk about dispute resolution, but some of the basic things involve active listening. When you're talking to someone, don't interrupt them, and try to avoid using the word but. That little short B-U-T is oftentimes kind of demoralizes the tenant. So it's better to use the word and. Say, I can appreciate your problem, and I hope you understand I still need you to pay your rent so my bills can get paid as well. If you said that, I can appreciate your problem, but then you kind of said you really didn't care about what they said. So avoiding that word is very helpful. Focus just on the facts. Getting the facts can be extremely difficult because everybody has a side, and if we all see the same thing, we're all going to report it just a little differently. As you get those facts, write them down and document what's happened. And also I would suggest try to get the people involved to send you a written statement of what they have observed or what the problem they think they're having. Also watch for nonverbal cues. If you're meeting with them face-to-face, that you might be able to notice, how they're approaching the situation, how their eyes are looking, facial expressions and things like that. Your body language as well as their body language can go a long way towards how you resolve a situation. If things get heated, take a step back. Take a break, schedule a meeting at a later time, and try not to get into a situation where it becomes a heated argument. It's much better to take that break and then deal with things in a calm, professional manner. Whenever you put something in writing to your tenants, whether it's a notice or a reminder letter or an email or a text message, whatever it is, remember that once you put something in writing, it's there forever. It's open to the public, open to interpretation, and very likely can be used against you in a legal proceeding. So be very careful with what you write and how you write it, and again, stick to the facts and what the situation is. And at last, be safe. You want to avoid any situation where you as the landlord or your staff may be at risk of physical harm. You might need to have a second person present, or if necessary, ask law enforcement to stand by if there's a critical situation going on that may involve violence or other problems. But as you're investigating and analyzing your situation, determine if it's an emergency, find out all the information, evaluate what you might need to do, and then determine your response. Maintaining professionalism is by far sometimes the hardest thing that we do, but it's something we need to do every day. Being consistent, being somewhat flexible, but remember, this is a business relationship. You want to make sure that you're perceived as being fair, but you're not a pushover. We need to understand what the tenant is saying. We want to make sure that we know what the laws are. We want to make sure that we don't have the perception of discrimination. See, human rights violations are different in every jurisdiction, and you need to be aware of what is valid not only on the federal level, but states, counties, and even cities have their own human rights rules and things that can be perceived as being discriminatory. For example, City of Seattle, political ideology happens to be a protected class. So having a conversation that might deal with your favorite candidate could be perceived as discriminatory in that environment. So be professional and be aware of what the confines are that you must stay within. You always want to be fair, but you also want to be impartial. Keeping records, being able to document everything, being able to show you've had training for fair housing, and require the people that work with you have that same training. Remember, as the landlord, when we send anybody to our property, whether it's to show it or to repair something or to do an inspection, they are an agent of the landlord. And as an agent of the landlord, we are ultimately responsible for what our employees and contractors might say or do while they're at the property. So you may want to require that anybody that's going to have contact with the tenant go through fair housing training. But you also need to be flexible. There might be times that you need to make an exception, but you want to have a good reason, a cause for it, and it's important that, again, you document that you're making a one-time exception because of this, and then it may not be granted again in the future. However, on that perception of being fair, if you allow one person an exception, you should be prepared to offer everyone that same type of exception on that one-time basis in a similar situation. Problems with tenants come in all shapes and sizes. It might be how they take care of your property, how they deal with you, how they deal with people you send to the property. It might be tenant versus tenant. It might be the way they pay the rent or not pay the rent. So all of these details of expected conduct should be addressed in your lease, whether by a term of your lease or a rule that's attached to your lease, whatever the law allows in your jurisdiction, to make sure that there's a clear understanding of what the expectations are. When it comes to pay rent, most areas have a notice that would be served if a tenant doesn't pay their rent on time. Here it's 3 days to pay or vacate, unless your contract is more forgiving. Many times that we find is we are allowed to be more relaxed than the state law that we have to follow, but we cannot be more stringent. So when it comes time to create our contracts or review our contracts, if the law says you must give a tenant 3-day notice to pay or vacate, or a 10-day notice to comply or vacate to a violation, but your contract says you're going to give them 5 days, that's okay. You can give them more. But you can't be more stringent and say only 2 days to pay or vacate, or you have to comply in 1 day or vacate. But oftentimes we don't want to jump straight to legal notices. When something goes wrong, you might want to investigate the situation. You might want to analyze it a little bit more to see what is really the problem. Maybe the problem could be something as simple as, there's some oil leaking in your parking lot. You might be able to resolve that by talking to your tenant, having a conversation with them, maybe following up with a reminder that vehicles, are not allowed to leak fluids. If the problem continues and isn't resolved, then it's time to go to what is your legal obligation and legal right. So as we figure out, what the problems are, investigating, first, did I witness the violation personally, or does somebody else tell me about it? If I witnessed it personally, I can document it, take some photographs of what I see. I, even during inspections, oftentimes takes pictures of any damage or things that the tenant may be responsible for, so there's a record. If it was the third party that told me about it, we don't want to be involved in a he said, she said type of conflict. So is there some documentation? Is there some proof? Is the reporting party willing to write it down and give you a written statement? How reliable are they? If there's a dispute between two tenants, are they willing to actually write down a complaint against the other party? And then we have to figure out, is it true? Is it a valid complaint? Sometimes I've encountered situations in dealing with single-family houses where I get a complaint from one neighbor against my tenant. But when I do an investigation and they don't want to put it in writing, they didn't call the police, there's no record that I can find. It's just a personality conflict between two individuals. That isn't something that I'm going to necessarily do something about. However, if you're in an apartment building and you're having that same type of conflict, you're going to have to deal with the tenant that goes to, I lost my show here. Where'd it go? There we go. I apologize. If you're dealing, back to an apartment building, that you have a conflict with one tenant versus another, now you may have an issue that you need to deal with more readily because it's going to affect, one tenant versus another. They're going to all talk about it, and typically the one that's probably your better tenant might be the one that decides they're going to leave, leaving you with the problem. So you have to decide, what is your potential loss? And what is your desired outcome? Sometimes telling a tenant to leave, and going through that process might be the best solution. But maybe there's another way. Sitting down, reaffirming your expectations, and having that conversation with somebody saying, I call it a knock and talk. I go and knock on the door and say, we need to talk about this. Sometimes, you find out that it's a situation that can resolve itself very quickly, or it's a misunderstanding. And you resolve that, and everybody's back on the same page, and things can be fixed. And then you determine your response. What is your response going to be? And then make sure you follow that same pattern of response every time that type of problem occurs. Some landlords, especially private landlords, will look at the idea of saying, well, I like this tenant, so I'm going to treat that differently than I would this other person. We can't do that. As professionals, we have to treat all tenants the same. So there might be 3 levels that you might look at as how to deal with this conflict resolution. It might be that friendly reminder, a conversation or an informal email or an email follow-up that you have some documentation that this took place and you've dealt with it. Level 2 might be a warning letter, or your contract may specify a fee. Many times, if the tenant is responsible, say, for cutting the lawn, and they don't do it, my contract says they're going to be charged a fee plus the actual cost of the lawn being cut on their behalf. If we have to serve a notice, there's a notice fee that's added. So what's legal in your jurisdiction, if it's in your contract, that might be where you go. And the level 3, the highest level, is what legal action might you need to take. A 3-day pay or vacate, if that's what you're allowed to do. A 10-day comply or vacate, if that's in your system of jurisdiction. Or if they're a month-to-month tenant and not in some controlled environment that allows you to just terminate at the end of a 20 or 30-day period, depending on your jurisdiction. Again, Washington is 20 days notice to vacate month-to-month. Other jurisdictions require a 30-day. And in some that have more restrictive areas, sometimes require a 60-day notice to vacate. But however that works, you'll now be able to figure out where you're going from there.
Terrific. Well, let us go into some tenant scenarios and see what landlords can do when they're faced with very similar scenarios. Are you ready?
I'm ready.
All right, so first scenario. Your tenant, who submitted multiple ridiculous repair requests since he moved in 4 months ago, texts you saying his toilet is making a weird sound. What do you do?
Well, the first thing you do is we have to investigate. We want to, if you don't have some terminology in your lease, you might consider adding something that would assess a fee if there's unfounded complaints. But if the tenant's making a funny noise, and it really is, you don't want to ignore it. So even though the last 5 times they've called have been kind of irrelevant, you still have to investigate and see if they're having a legitimate problem. And then take care of it.
That's very fair. All right, scenario 2. Your tenant emails you saying she noticed some sewage backing up in the basement storage area. She moved everything out of the way, so it's not an emergency, but it smells bad. Uh-oh, what do you do?
Well, hopefully it's not nearly as bad as the photo you're looking at. But in this case, this would be considered a health or safety issue. In Washington State, that's a 24-hour required response that you're going to have to deal with. Even if the tenant says it's not an emergency, we have to react because having raw sewage inside the dwelling is unsafe and unhealthy for them and can cause significant damage to the building. So you want to deal with that immediately.
So you're saying that anything that is immediate, even if the tenant's not concerned, you're able to respond to, or you should respond to, depending on your state law, within 24 hours?
Exactly. I mean, just because the tenant's not concerned about it doesn't mean that it's not important. I mean, having sewage inside your building, as we're showing here, inside a basement, could be, you're going to have that odors seeping up into the property and gases from sewage that seep up that, they may not ever go into their basement, and don't care, but you don't want that, soaking into the walls, and it just becomes a bigger problem. So I would contact my sewer company immediately. Now, if my sewer company said this was caused because of the tenant misuse of the system because they threw a bunch of paper towels or their spaghetti spoon went down the toilet and it caused the problem, then the tenant may be liable for the bill for the repair and the cleanup. So that becomes, it depends, but it still has to be dealt with and investigated.
Got it. All right, scenario 3. Your tenant includes a note with a rent check saying they applied $42 of their rent to an expense for fixing a dripping faucet.
Well, this is going to depend on jurisdiction. Typically, tenants cannot withhold rent to do a repair on their own unless they followed whatever the state law allows. Now, several states have a Landlord-Tenant Act, as Washington and California and other states have, but others do not. So then you have to resort to what does your contract say. Does your contract even speak to the tenant withholding rent for repairs? So it's important to say if the cost is reasonable, you might choose to give them the credit this time and then follow up and say, in the future they need to notify you so you can have your repair people take care of problems to know that they were done correctly and they aren't going to become a recurring issue. Under Washington law, the tenant is allowed to withhold rent in certain cases after they've done the written notice, after they've submitted bids, and the owner keeps not responding and ignoring the problem, but keeps collecting the rent. Eventually, the tenant can withhold a certain amount towards repairs.
Okay, so always check with your local laws.
Always know what your local law says, whether there's a separate landlord-tenant law or separate contract laws that might deal with these situations, or if you're dealing in a state that does not have a landlord-tenant law that protects, these kind of situations, you should consider language in your contract of how to deal with situations like this so that it's, a clear understanding that the tenant cannot withhold rent
right
in lieu for a repair. So if you don't have the state law to back you up, you want to have something in your contract. And whenever you're writing something in a contract, make sure your attorney has reviewed it to make sure it's valid and legal in your state.
Absolutely. All right. Scenario 4. Your tenant emailed you 3 days before rent was due, saying she had an unplanned expense repairing his 18-year-old economy car. He'll be $200 short on his rent payment, but he can pay the remaining amount when he gets his next paycheck the following week. He's paid consistently for the past 8 months. What do you do?
Well, this one comes up, there's a multiple choice. Different choices depending on how you want to deal with this. Some owners will not accept a partial payment at all. You either pay the full rent or you're going to pay the late fee and you're going to get your notice to vacate. No exceptions. They do it for everybody. Everyone's the same. Other owners are a little more forgiving and they would accept the partial payment and would allow them the extra time on a one-time basis, with or without a late fee is up to you again. Personally, I use a percentage late charge system based on the balance owing when the late charge is added to encourage the tenant to pay as much as they can as quickly as they can and have a penalty on what they haven't paid. So if they only owe $200 and I charge a 10% late fee, I would only assess a $20 late fee on top of the $200 and they would pay me $220 next Friday. Some owners would choose to accept the partial payment but also issue the notice to pay or vacate for the balance. This allows you to wait until the agreed time, because just because the notice might say 3 days pay or vacate, it's okay to wait 4 or 5 before you take legal action. But if you're working a week ahead, you don't want to have to start with a 3-day notice. So if they're going to pay the rent next Friday, and Friday comes and goes and they haven't paid and you don't work on the weekend, so on Monday then you serve them a 3-day, you've now lost 10 days.
Right.
So a lot of times owners would do a 3-day pay or vacate and accept that payment on Friday, which would cancel the notice. If they don't get the payment as agreed, that following Monday, they can start their eviction and legal proceedings and not have to have the delay.
That makes a lot of sense. A lot of options there for various landlords.
And again, whatever you choose, do it the same for everybody in that situation, so you aren't perceived as treating one differently than another.
Right. All right, scenario 5. Every month since your tenant moved in 4 months ago, she's paid rent 2 days late. In your lease, you have a 2-day grace period before a 10% late fee is applied. You haven't seen this month's rent yet, and it's 3 days late. What do you do?
Well, first I would probably look at my calendar And if the first 2 days happen to be like Saturday and Sunday and, or Sunday and Monday being a holiday or whatever, like we have Memorial Day coming, I would probably give them an extra day or so before even reacting. And if I got it on the third day or the fourth day, I probably would just accept it and move on and hope that they would go back to their normal pattern the next month. Second thing, I would look at their contract. A tenant that's on a lease doesn't have to give you notice unless the lease automatically continues on some kind of month-to-month basis. So if you have a lease and it expired on May 31st, and you didn't get the rent on June 1st or June 2nd or June 3rd, if you hadn't negotiated a lease renewal or some extension, they may have vacated and had been perfectly legal to do so, because an expired lease, there is no notice needed, because the ending date of your lease or your tenancy was established on the day they moved in. You know that they moved in, in June 1st of last year, and the lease expires on May 31st of this year, a year later. There's no obligation for them to be there or pay rent come June 1st or 2nd. So I would go look and see, maybe the property is vacant. Or if you are a P.O. Box person, I would probably go check my P.O. Box and make sure I didn't miss a notice that may have been sent in saying they were moving. But once rent is unpaid, you could visit the property to see if they vacated or have abandoned the property, which abandonment typically means they left the property, they didn't pay the rent, but their property is still there. They still have their furniture and stuff in the property. And then there's, most states have a abandonment law that would give you an outline of what procedures you need to follow, a notice to enter, and things like that. And then you would check it 2 days later and then find out if did they in fact leave. If they've taken their clothes and they've taken their food, but they left their old furniture behind, that's an abandonment. And then the law in Washington says you would store their property for 45 days and then get wherever, either on-site or off-site, in someplace reasonably secure. If it looks like they're still living there and they haven't paid and you haven't had any contact, that might be the time you need to post that pay or vacate notice. And if you don't get a response, then you need to start your eviction.
Got it. That makes a lot of sense. All right.
Whoops. I think I asked you on there. I hit the wrong mouse.
There we go. All right. So you've had the same good tenant for years in your rental property, and you rely upon the rent for your monthly expenses. He recently lost his job and has not been able to pay rent this month. What do you do?
Well, while the tenant had an unfortunate experience, you would need to, this is one of those and statements. I understand that you're having a serious problem with, because you've lost your job and, you're not able to pay, and the rent still needs to be paid. It's hard not to say but, because I almost said it right there. And when you get into that and you explain, we still need to work this out. Now, you have to, we go back to the scenarios and how to deal with that. You have to evaluate what the potential loss might be. If you think that they're going to be able to get back on their feet and starting next month they're going to pay on time as regular, you might make an exception to allow them to skip that month's rent and then make a payment on that rent over maybe an extra $100 a month over the next so many months until the rent is paid for the missing month. Because a turnover is very expensive. Forcing them to leave will probably go to an eviction because they don't have any money to move. They can't rent somewhere else because they don't have money to put down for screening and deposits and rent somewhere else. And so you end up going through an eviction, which is expensive and could take 30 to 45 days depending on where you're at. And then you still haven't got the rent. And then when they move out, you have the turnover and the damages and the repainting and the carpeting and the cleaning and all the other things we have to do between tenants.
Right.
So I would look at the ideas, and I did this when the market, was really kind of crummy several years ago, and I had several tenants that kind of got a little underwater with losing jobs or whatever, or between jobs, and I put them all on this plan where they And 4 out of 5 tenants actually were able to pay on that payment plan and get out of their hole.
Wow.
One ended up having to move anyways because they just couldn't do it. My loss was because I gave them the month and then they couldn't pay the next month. I had wasted that whole month, and I had to start the eviction the second month. But it was a calculated risk because I was calculating what it was going to cost to turn over the unit, how long they had been there, so how much work was going to need to be done, and then how long it might have to sit vacant because there was so many units available on the market at the time. Now, in today's market, there's almost no vacancies available. I might be a little less forgiving because I could raise the rent considerably on a re-rent and not be as motivated to work with somebody. So there's lots of conditions that could apply.
Absolutely. All right, next scenario. We've got a lot of questions on this one, so I think it'll be useful. A tenant complains the smell of another tenant's daily cooking is nauseating. When you follow up with the cook, she says her neighbor is a bigot and always is complaining about the smell of her curry. What do you do?
This one, I say, requires a little bit of special touch because you want to make sure that you're not being discriminatory yourself and how you respond, because of a culture they use certain spices and certain foods is normal for that person. And so, first of all, do you have any rules in your contract that you can refer to? Sometimes it would be a good idea to ask the tenant that's complaining, the neighbor, to invite you over when the problem is actually happening, and then you can evaluate it for yourself. Then you know, are they being overly sensitive, or is the smell really so bad that you can't breathe? You know, if you can verify that the problem exists.
Right, that avoids the he said, she said, too, when you're there and you get to experience it.
Yeah, if I can experience the problem, it takes the conflict away from being tenant to tenant, because that was landlord to tenant, and saying, I couldn't live in that either. And so then the next thing before you would, not a lot you can do on a legal basis, but are there some environmental changes that you might be able to do? Maybe you can install a new exhaust fan or put a higher volume fan in that moves the air out better. Maybe there's some gaps where there's air exchange taking place between the two units that might need to be sealed or caulked or something to allow their smells to stay on their side of the wall. Really touchy on how you might respond without stepping on the toes of the other person.
That makes a lot of sense. That does sound like it needs a very delicate touch, though.
It does, because you have all of these potential complaints, because they're going to say, well, you're doing this because, and then you have to be able to prove that, no, I'm doing this because I can't live here, I can't breathe here, or I'm sensitive to smell and I can't be there. And another solution, if you're dealing with an apartment, is maybe offer the offended person, the one that's having the issue with the smell, give them the option to move to the next available unit, to make it better for them without doing something with the one that might be a cultural issue that might, be a discriminatory act, to try to get them to move.
That's a great option if available. All right, our next one's a little seedier. A tenant lets you know that the neighboring tenant had a loud party, and she called the police. The next morning, she saw drug paraphernalia in the front yard. As a landlord, what do you do?
Well, this one requires a very full investigation, typically by contacting the police department. I have a very good relationship with all of the liaison officers that are out assigned to each area of our city that allows me to call somebody and say, what's taken place on my property? I understand you were there. Tell me what happened. And these liaison officers are allowed to share a little bit more information. They won't give you a copy of the report per se. You have to go through that procedure to obtain a copy of the report separately if you need one. But the officer can say, yes, we were there, and there was a domestic kill or whatever it was, and there was an argument, And you can ask, was there any drugs, being used or any paraphernalia visible during the visit? Because the officers may have noted that in their report. If you can get third-party verification that the paraphernalia seen in the yard the next day was maybe related to the loud party the night before, you might have something that you can give notice to the tenant for violating your contract and having drug activity and whatever going on your property. But otherwise, there's really no correlation, because just because they saw the paraphernalia outside one day and the night before there was a party doesn't mean they're related. So I would typically do a knock and talk and visit the place that had the loud party and say, you had this violation of our noise things, and I talked to the police department and they said this and that, And if you get any evidence of actual illegal activity, then it's the landlord's best interest to remove the problem so that you aren't complicit with the problem, where the city can say you're participating in the drug activity, so now they can abate your property. So then you would serve the appropriate notices and proceed if you could have some proof or verification.
That's great. So we've got a question here that was, how do you best communicate with your tenants? Do you use email as a form of communication, or what's your preferred method?
My preferred method of communicating is to send a written letter. I'll give you, from Washington State, the courts in Washington do not look at text messages as evidence. Most of them don't even consider emails as messages, as any evidence in a proceeding. They want to see hard written notices. So, if the tenant's complaining about, I have tenants that will text me and say, I have a leaky faucet, and I'll say, yeah, I got it, and I'll send my maintenance out. That's fine. But when it comes to needing to give the tenant a notice I'm going to go inspect the unit, I'm going to show the unit, I'm going to send repair out or whatever, those notices usually required to be in writing on a piece of regular paper, plastered on the door so anybody who walks through the door can see it.
Got it.
I prefer to communicate. I email to my tenants. I have a portal system with my software. I have lots of ways of communicating. But when it comes to something that requires legal, written is the answer.
Written is the answer. And you said that you don't even mail it. You can put it on the door itself?
Well, it depends on, that's a state law question. In Washington State, any notice that we have to attempt to personally serve the tenant, say a pay or vacate notice, we knock on the door and have to try to give it to them. If they don't answer, or they're not home, or they refuse, the law allows us to post it, one for each person on the door, and then mail one by regular mail to each named tenant separately.
Got it. And if they don't check their mail, that's not the landlord's problem, is it?
Right. No, and the law requires in Washington that we send by regular first-class mail. So,
Got it.
Depending on some states do say certified, so you need to know what your state says. Thing is, you don't have to accept certified mail. You can just not sign for it, and it's never delivered. Regular first-class mail is always delivered, and the tenant might throw it in the garbage, but that's up to them. There's a tool that the post office offers called a certificate of mailing, and it's like $2, or maybe it's a little less than that, in addition to the postage, where you deposit the mail with a certificate at the post office at the window, and the post office will give you a stamped, dated receipt saying you did place a piece of mail to this address. They don't know what's in it. Nobody has to sign for it. But you have a receipt that you did place this item in the mail, and that's available anywhere in the country, called a certificate of mailing. And that we attach that to the paperwork, showing that we posted it, we handwrite, posted it, take a picture of it on the door, and then we mail it with a certificate, and then we have proof that we did mail it to the tenant on the same date.
Wow, what a great resource. All right. Scenario number 9. A tenant complains about the noise of another children's. What do you do as a landlord?
Well, this one, we're on scenario 9.
Mm-hmm.
There we go. I would handle this with a visit followed by a warning letter reminding tenant of what the quiet hours are. If children are not being supervised properly, that's kind of very subjective. But if they're intruding on another tenant's private space, like their patio or their yard or their deck, then you may have reason to take other action or issue a notice to comply. Some jurisdictions you'll need to handle these in a specific manner, like if they're on a lease or they're in a protected jurisdiction that has rent control and other regulation, may require that you have multiple notices to comply before you can actually evict somebody for a problem, to show that there's a repeating offender.
Right.
But it's really hard to say that kids make too much noise. You can't discriminate against the kids. Again, if you're in an apartment, I like single-family houses, so I don't have to deal with this. But as an apartment, and you own an apartment building, again, it might be something that, the person that has the issue, you might give them an option to move to a different location should one come available as a possible solution, but typically you can't say anything about the kids too much as long as they're being properly cared for and they're not intruding.
Right. Absolutely. All right, we'll go to our last scenario, and then we've got some Q&A. So, last scenario. It's the dead of winter, and your tenants go away for the holidays. They forgot to take care of the pipes, and when they return, they're completely frozen and damaged. They want you to foot the entire bill. What do you do as a landlord?
Well, I've had this happen to me. So, we have actually gone to the point now that we send out an annual notice to our tenants in the form of a newsletter specifying what we expect the tenants to do in the wintertime. We remind the tenants what their responsibilities are if they're going to be gone from the property, how to prepare for winter weather, how we define their expected reasonable precautions, like minimum heat settings in the property or having doors open and cabinets open to allow airflow between rooms. But if you don't have such notification, which are considered rules under Washington law, it might be difficult to assess this cost to the tenant, because unless they've violated some term of your contract or of law, the statutory duty of the tenant in Washington doesn't say they have to do anything special regarding winter preparations. They don't have to do, they're not responsible for damage caused for not doing what I might think is appropriate. So you end up probably filing a claim with insurance. If the tenant has renter's insurance, you can see if they think there's any liability there. File it with your own insurance and let them subrogate over to the tenant's policy if there is one, for any damage that might be occurred from the actual broken pipes.
That's great. Those are some great tips. All right, so we just have a few minutes left, but we had a few questions that came in over and over again. So I'll start with the first one that I saw. Someone not on the lease moves in. What do you do? Whether it's a boyfriend or a dog.
Boyfriend or a dog. Typically, sometimes it's even the husband.
Yep.
Typically, we would send a notice of, that they have unauthorized people on the property that have exceeded whatever your guest allowance is in your contract, and ask them, if they plan on remaining because they are the boyfriend, the husband, whatever, that they go through our screening process and get added as an additional occupant, as long as the unit is big enough to accommodate the extra people under any occupancy standard that you might have. If it happens to be a dog, instead of a person, we don't screen dogs, but we would send a notice that they have an unauthorized pet and it's a violation of your contract that says no pets. Please remove the pet from the property.
And then would you go through steps, if they didn't remove the pet, would you go through the next steps of giving them a few notices before going on further legal action?
Typically, we would get multiple notices that the pet's still there. Every time you see the pet, pictures are cheap on digital cameras now. Take a picture of the date and time that you see the animal there today. You see the animal there a week from today. You see the animal there 3 weeks from today. The problem that you have, and it's why I really don't like leases, I prefer month-to-month contracts. In Washington, I can evict somebody on a month-to-month agreement for no stated reason unless they're in a just cause jurisdiction like City of Seattle. And I can just say, we're not doing business anymore, you need to go, and I don't have to prove why. If they're on a lease, you're going to have to prove the violation. Now, at one point in time, we had this go to court, and we were talking about an unauthorized pet, and the tenant testified in court saying, I took the dog to the pound yet last night. And the judge is about ready to throw the case out of court because it's resolved, the pet's gone.
Right.
My saving grace was on my way to court, I had a picture on my phone of the dog still there 15 minutes before court started.
Oh, wow.
And that's the only reason I was able to prevail in the lawsuit, to evict the tenant. Otherwise, the judge was just going to throw it out because they said they complied, the pet's gone, by their testimony, and he started to say, excuse me, Honor, the pet was there 15 minutes ago or a half hour ago. And they said,
right.
Oh, let me see that. And they said, okay, and they signed the order.
Document, just like you said earlier.
And the thing is, it's hard to prove any violation. Violations of no smoking are very hard to prove because possession of cigarettes and a lighter doesn't mean they're smoking on your property.
Right.
So you have to be able. So it's a lot of times it's easier if you don't have to prove your case. You can just say we're done doing business. And I've had month-to-month tenants for 17 years. Doesn't mean they're going to move out in 3 months because they're on month-to-month.
No.
A lot of landlords think they have to lock them in for a time frame. The problem with a lease is you have to prove the violation, but if the tenant gets up and leaves, there was one question I answered online a little bit ago, talked about what if they move out and the lease isn't over? Well, they're gone. You can charge them for it, but collecting is the next part. That's very hard.
Absolutely. Well, thank you again. Thanks so much, Steve, for joining us today. We'll definitely hope that you can join us in the future. For everyone listening, if you did not get your question answered, we will try to continue answering them after the webinar here. But don't forget to take our survey at the end of the webinar. And thanks so much for joining us. We'll see you next time.